just a minute, my lords, aside.
Who are the applicants?
The applicants, my lords, are persons, displaced persons from that portion of Jammu and Kashmir, which is now called Pakistan-occupied Jammu and Kashmir. They represent that set of people, my lords, and their interests. These are the interveners. With prejudice to my time limit, which my lords have given, just an aside, my lords, I'm reminding myself of being that apocryphal son-in-law under Hindu law, my lords, which Sir Alladi referred to. Apparently, my lords, there was a very intricate problem of Hindu succession under Mitakshara and Dayabaga law before an English judge. The questions were getting so complicated that the judge tongue-in-cheek asked Sir Alladi, what would the son-in-law get? I believe Sir Alladi said, whatever he is able to lay his hands on. That my lords, seems to be my position in terms of, my lords, both time and submissions to really.
So what is the key submission?
Key submission, I'll refer to this, my lords. The rights perspective is probably the decisive factor in determining, my lords, the tenability of the challenge which has been mounted by the petitioners. In other words, my lords, the rights perspective will trump or override all or any contentions or allegations of processual infirmities. And the reason why I'm making the submission is this, my lords. Whether it be these intervening applicants or any of the other intervening applicants whom Mr. Salve represented, Mr. Giri represented, or for that matter, Mr. Jetmalani represented, they represent a cross-section of people from Jammu and Kashmir who have suffered discrimination and loss of rights. Therefore, they impugn COs which make provision for rights for such people across the spectrum. The validity will have to be seen in that perspective and in that light. That's my submission for my lord's consideration. For example, my lords, these intervening applicants whom we are referring to, they are probably, my lords, the first victims of the problems which occurred during partition. When the aggression took place and the incursion came, these are the persons who were displaced by force of circumstances from those areas, Mirpur, Gilgit-Baltistan and all those places. They moved therefore to other parts of Jammu and Kashmir and to other parts of India. Now, what is really the problem that they have suffered over the decades now? Because of Section 6 of the Jammu and Kashmir Act, Jammu and Kashmir Constitution, and 35A of the Constitution of India as applicable to Jammu and Kashmir. 6 purported to set out who permanent residents are. (35A) introduced, my lords, by constitutional order in 1954. CO 48. That, my lords, provided that permanent residents, as defined in 6, they will get certain benefits. And the fact that persons who are not permanent residents will not get those benefits cannot be called in question as a matter of justiciability.
Guru, just one clarification.
Yes, Manoj.
People who came from the Pakistan-occupied Kashmir,
Yes.
they were not given rights under 35A?
No, for the reason why, I'll tell my lords why. Because that referred to permanent residents. Permanent residents as defined in the Act is any citizen of India, but subject to 3 important riders. Rider number 1. The person must be a state class citizen 1 or 2 as of 14th May 1954. 1. 2, he must be ordinarily resident in the state of Jammu and Kashmir during a period of at least 10 years prior to that date. So the date is shifted back to 1944. That, therefore, my lords, meant that even those who were there citizens in Jammu and Kashmir in their own right, because of the external aggression during September, October of 1947, they are excluded. That's where the pinch is, my lords.
If they had settled down in other parts of the country, they would have got citizenship.
No, they would have had to be only,
Other parts of the country.
yes, they won't get. If you're in Jammu and Kashmir, yes. But if you went to other parts of the country, you won't get.
Sorry, you're saying
Yes.
the other way around.
May I show 6, my
You're
lord? May I
saying
show?
the other way around.
No, may I show 6, my lords? Can I show 6? Give me 6. Just give me 6.
Jammu Kashmir Constitution is in part 1
Yes.
of the document. Part 2. Part 2.
Volume
1 and 2.
2, my lords, page 18.
Well, I'm sorry to interrupt. There are 10 petitions here which challenge 35A. Well, those have to actually be de-linked because we're not here concerned with the challenge to 35A. We're concerned with 370. So, well, all that is fine, but that's not to be decided by your lordships. If this is upheld, if what the union is saying is upheld, this is unnecessary.
That's right.
Doesn't exist.
It's simple. Therefore, we are going into this.
I'm only saying, Malaz, this is only to
Let's-
take up the
let's-
time of the court. That's all.
Every person, I'm at, my lords, volume 2, PDF page, my lords, 18. Every person, may I read it, my lords, is deemed to be a citizen of India under the provisions of the Constitution of India, shall be a permanent resident if on the 14th day of May 1954, he was a state subject of class 1 or of class 2, or having lawfully acquired immovable property in the state has been ordinarily resident in the state for not less than 10 years prior to that date. Any person who before the 14th day of 1954 was a state subject of so-and-so, so-and-so, and who having migrated after 1st day of March 1947, this is an anomalous provision. I'll just show that, my lords. So the first part is 6.1. That talks about 2 dates, 1954 and 10 years prior to that. Second,
It's an alternative. A and B is an alternative.
that's right. Or, that's right. That's right. But then in terms of actual application, they have always been applied together. All these are persons,
They have been applied, treated as cumulative.
yes, you are outside Jammu and Kashmir, you don't get it. In fact, I've given in my application, my lords, the case of how 8,700 people and odd people left that place during that time, during partition. Today, my lords, after the promulgation of the impugned COs, at least 23,000 people have received domicile certificates. About 24,000 people. We have mentioned that in our submissions.
So state subject of class 1 or clause 2
Yes.
is defined in clause 3,
Yes,
subsection 3.
yes,
Namely, that refers you to
1927.
So
That's right.
you're out there.
yes.
You don't come in there.
No. In fact,
Clause 2.
no, because by 47, by 44, what happens is this, my lords. They expect you to be holding property as of 1944. And even though I qualify, in fact,
Let's say in POK, they're not governed by clause 3 of section 6.
no, my lords, what will happen? They will be governed by clause 3. That's why I'm saying it is applied cumulatively. You should be a state citizen, state subject of class 1 or class 2, and you should have been holding.
It says or.
No, but cumulatively it's being applied where you should have held property as of 44.
But then, Mr.
No, all I'm saying is this.
Mr. Krishnakumar, I don't think 2 can be read as cumulative because it imposes a condition of
No,
owning a movable property.
No, I follow.
That owning property.
No,
No,
I understand. But the fact of the matter
It
is,
cannot be. It cannot be.
the fact of the matter is, my lords, they were entitled, but they have not been provided. That's the
Not-
factual position.
Only thing is because under A and B, if you're not under A, if you're class A and class 2 citizen, then you have to go for 1927.
1927.
Get documents of 1927 will be very difficult for anybody.
That's another aspect, my lord. Absolutely. I bow down to that.
Now in clause B, prior to that date refers to which date? 14th of May 1954?
Yes, that's right. 1954. That 14th of May 1954.
Yeah, for clause A, subsection 3 applies.
That's right,
There
27.
is a 1927 order.
Correct.
For clause B, you have to own property and you must have been ordinary resident at least for 10 years prior to 14 May 1950.
I vote on.
Right?
And
So
that
anybody
date,
from 14th of May 1944 onwards
that's right.
comes within the purview
You
of
should have held
policy.
property. And that 1954 date, my lords will recall, is the date of CO of 1954.
That's also very odd because to
Yes,
say that you must own a property to get citizenship.
exactly. Now, one more thing, my lords, one more aspect, my lords. Please have a look at section. Yeah, that's right. Yeah. It's a
You're really trying to say is you're supporting the CO 272 and 273
correct.
by pointing out the anomalies which would otherwise arise as a result of Article
I
35,
bought on.
Section 6 and 35.
I bought on. The challenge, my lords, would really mean that they want to resurrect, amongst other things, this and 35A. That's the point.
Of course, challenge to 35A has.
It stands. But
kept aside.
I bought on, my
An
lord.
application to assist. Otherwise, that challenge has been kept aside to await the fate of the decision.
I bought on, my lords. But then
Provision-
I am saying
provision-
that this is important.
A provision which doesn't exist as of now cannot be challenged.
No, that's true. The effect of upholding the COs is to ensure that, my lords, this anomaly doesn't exist anymore. I am respectfully submitting, my lords, that I am placing this submission from the perspective of rights which are being made available by the impugned COs. That's the point I'm making. One more anomaly to add to what fell from my Lord Justice Khanna may have a look at it. Section 2, subsection 2. Any person who before the day of 1954 was a state subject of class 1 or class 2 and who having migrated after the 1st of March 1947 to the territory now included in Pakistan, returns to the state under a permit for resettlement in the state of a permanent return issued by or under the authority of any law made by the state legislature shall on such return be permanent resident of the state. So you make an exception out of this by saying those persons who may have gone to Pakistan, if they come back, they'll get the benefit.
Any persons also who was.
Yeah. The anomaly is writ large.
No, this included in Pakistan will not include Pakistan-occupied.
No, it won't. That they are very clear.
It will not include Pakistan.
No, it won't. That's why a separate provision is brought in.
It will be portions other than.
Than POJK. There is one other, my lords, very ironical aspect. The Jammu and Kashmir Constitution makes provision for seats for POJK in the assembly, but says because it is under. 1 minute.
Time is up.
I know, my lords. That's why. No, now there are two other perspectives I'll place and then I'm done, my lords. In fact, this is something which nobody has referred to. That's the reason why I'm even troubling my lords with some of the nitty-gritty of this, my lords. So this is one aspect. 35A, just have a look at that for a minute, my lords. Now, because there's a striking parallel to 31B under the Constitution. Koilo, please see the kind of dilution which took place in Koilo. Just have a look at 35A for a minute, my lords. This will be volume 1, PDF page 99. Notwithstanding, may I read the colors? Notwithstanding anything contained in this constitution, no existing law in force in the state of Jammu and Kashmir, and no law hereafter enacted by the legislature of the state, defining the class of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or conferring on such permanent residents any special rights and privileges, or imposing any other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or rights to scholarship or such other forms of aid as the state government may provide, shall be void on the ground that it is inconsistent with or takes away or abridges rights conferred on the other citizens of India by any provision of this part. Now, 31B, my lords, under the Constitution provides that anything included in the 9th schedule shall be immune from challenge on grounds of violation of Part 3.
Guru, now I also note that in your written submissions, you've
Yes.
really highlighted, what was the anomalies and what has been restored now.
Exactly.
The rights perspective. So
That's right.
I think let's go into the
Just
next step. Yes.
three more things, my lords. I'll take only 3-4 minutes, my lords. Now, 31B in COILO, my lords, very extensively referred to the foundational value of the fundamental rights. Golden triangle of 14, 19, and 21. I've given all those paras in my submissions, my lords. In fact, I've given the extracts of all those paragraphs in COILO. Now, ultimately, my lord said, you cannot take away judicial review and any law included in the 9th schedule can be tested on the anvil of basic structure. Now, surely you cannot have a position, and that's what petitioners are bargaining for. What was there in the original constitution, my lords, this is the approach of this honorable court. The petitioners can't bargain for a position where the Jammu and Kashmir constitution, which is admittedly inferior in terms of, my lords, the constitutional governing instrument than the Constitution of India. They have something better than that. This is the kind of importance which has been given under the constitutional scheme of India. In fact, 31B itself, my lords said at one part in paragraph 78, just make a note of it, the validity of 31B was not in challenge and therefore my lords did not go into it. My lords assumed that in Shankari Prasad and in Sajjan Singh, it was upheld, therefore my lords didn't go into it. But instead, judicial review cannot be excluded. And you cannot say, by placing it there, I'm making it immune to challenge. That's precisely what 35A purports to do. That's the second part, my lords. Third part. Ultimately, my lords, all the nuts and bolts and the nitty-gritty looked at. What does it come down to, my lords? The basic structure is the ground norm. That's the touchstone on which any constitutional decision-making has to be considered. The validity of any constitutional decision-making has to be seen. Today, what are they, my lords, arguing in terms of basic structure? At the highest, apart from, if I may say so, diffuse arguments of fraud on constitution. Two square features which they want to invoke, my lords, in various forms. One is federalism. The other is, my lords, representative government. So far as representative government is concerned, I think that already the solicitor has pointed out, it's a Puducherry model, there is representation. So far as federalism is concerned, the highest that they are able to put it on is some kind of a derivative form of federalism based on what my lords have said in the 2023 NCT judgment. That's the highest they want to put it at, where they say that my lords are referred to an asymmetric federalism. Paragraphs 40 and 41 of 2023, my lords have been given, the citation is there in my notes of submissions. What they want to say now is, asymmetric federalism has been recognized. Now, please stretch this and say the multisymmetric federalism of 370 should also be taken to be a basic feature of the facet of federalism. That's the argument. I'll give the page numbers of Dr. Dhawan's arguments. Page 280, page 211, volume 1 of submissions. After extracting from my lord's decision in NCT in 2023, they say that this now has to be stretched further to say multi-symmetric federalism. There, para 40 and 41 of 2023 at the risk of carrying coal to Newcastle, my lords. My lords, interestingly, have referred to 371 and all those provisions for various states by way of special provisions. My lords there refer to how they are special provisions in 371. And it is on that basis, by relying on the marginal note. My lords have pointed out how constitutionally some kind of asymmetric arrangement has been made. So it is on the basis that it is a special provision in 371. Today, what they want to do is equate 370, which is temporary, with 371 special provision. I hope I'm making myself clear.
Yes, yes.
Therefore, that is why I said it's a derivative argument they want to make. 371, my lords, consciously referred to the marginal notes and said how these are special provisions. And that's how they provide for special provisions. That cannot be stretched, my lords, to say that it has to be applied to 370. The temporary character, nuts and bolts of 370, all of them have been argued, my lords. I don't want to take the time anymore. I'm adopting those arguments. In the light of that, my lords, I would respectfully submit. In fact, the impugned COs are reflective of transformative constitutionalism. What was argued by Dr. Dhawan, in my respectful submission, the boot lies on the other foot. The impugned COs ensure that the Constitution of India, with all its plenary scope, applies to the state. In my respectful submission, my lords, the challenge of the petitioners is really a contradiction in terms. Because this is a case where the application of the Constitution of India, the plenary document, is sought to be challenged. The effect of the COs is to ensure that the entire Constitution applies to the state, with all Part 3 rights, with all the other provisions. And even on federalism, my lords, there is one other portion in the opening remarks of Dr. Ambedkar while placing the draft constitution, my lords, before the assembly, constituent assembly. I've extracted. No, there is another portion apart from what Mr. Giri read. So I've extracted that in my submissions. My lords could have a look at that.
We'll see it.
Therefore, my lords, in sum and substance.
Thank you, Mr.
In sum and substance, my lords, this is for perpetuation of vested rights. And the COs, my lords, make provision for realization of rights under the Constitution.